Welcome to Lawline with your host, Alan Schnorman. Mr. Schnorman is a distinguished trial attorney, author, and lecturer. Each week, Lawline will bring you the most knowledgeable experts in the field of law today. And now, we introduce our guests and our host, Alan Schnorman.
Welcome to Lawline. The advent of court TV and recent high-profile cases such as O.J. Simpson, Susan Smith, the Menendez brothers, has brought the judicial system into millions of homes. Never before have judges, lawyers, witnesses, and jurors come under such intense scrutiny. Today we're going to look at the responsibility of the media to accurately report the judicial process and the participants in it. Our guests are the Honorable Edward Rappaport, Justice of the Supreme Court, and Barry Kamens, past President of the Brooklyn Bar Association. Hello, Judge. Hello, Barry. Judge, O.J. Simpson is on everybody. You can't open a newspaper without seeing it. Everybody knows about the verdict. What did you think about Judge Ito?
Well, firstly, Judge Ito made, in my view, the trial a little bit longer than it should have been. Many of his decisions were too well thought out and labored over and so forth. It's very difficult, I guess, in such a high-profile case to do otherwise, particularly with the television cameras in the courtroom and to the breadth that they permitted those television cameras
now,
to be in.
Now, you presided over the Yankel Rosenbaum matter. Also, TV in the courtrooms every day. How do you compare that case with the O.J. Simpson case?
Well, firstly, one of the things we did in the Crown Heights or Yankel Rosenbaum case is that many of the discussions that I had with the lawyers or applications that dealt with law that the jury was unaware of were not done in front of the media or the television cameras.
The question is the sidebars. Ito lost control of the courtroom, and he conducted an inordinate number of sidebars, and this affected the jury because the jury was getting tired of the sidebars, and as Judge Rappaport said, he conducted his trial much differently.
Judge Rappaport, do you think he lost control?
Of the case? No.
Yes.
I had difficulty with the lawyer because I had a difficult lawyer.
Did Ito lose control of the case?
Yes, very much so.
Do you think it affected the verdict?
Probably. Well, there's a difference that starts off immediately between the two trials. My jury was not sequestered, his jury was sequestered. And that's another problem. But you know, it's interesting. After the many months of the televised trial, the Simpson trial, legislators, people, judges, people connected to the system, public in general, said take the cameras out of the courtroom. If we are to use the O.J. Simpson trial as whether we should or should not have the cameras in the courtroom, they're not going to be cameras in the courtroom. But I think it would be a terrible mistake to take this one trial and use it as a criteria whether they should or should not.
Barry, you think Ito affected the verdict?
Yes.
Tell me how.
I think that he lost control, and that by sequestering the jury for the length of period of time that the jury became so, there was such great difficulty in being sequestered for that period of time that the jury was affected to the point where I think the verdict in part had to do with the length of sequestration.
Judge, were you surprised it was only 3 hours?
The deliberations, well, yes and no. The yes is that you would think a jury in such a serious case would take a lot longer, just if they were pretending to take a lot longer. What I mean by that is it's hard to believe that a jury reached a verdict knowing the importance of the case. I mean, they were sequestered and so forth and did it in 3 hours with such little instruction and readback from the court. However, I'm not surprised because what happens here, although we tell the jurors not to talk about the case and not to have anything concerning the case, to keep an open mind, these jurors didn't know each other. The only thing that binds them together, the only thread that goes through their existence is the fact they're on this jury. And when it gets such a long time, when they're with each other constantly, eating, being entertained constantly, being in court, it is impossible that they didn't bond. So what really must have happened, even before they started deliberating, they must have all had a common verdict. So it was easy to get a verdict.
And the ironic thing about the sequestration is that there were conjugal visits that were allowed by Judge Ito. So if you're going to sequester a jury, you have to sequester them. You can't allow family members to have conjugal visits because obviously what they were bringing into these jurors, to members of the jury, was information.
Information that was out in the
public. Which is called pillow talk.
Well, that was called pillow talk. I don't care what you call it, but information was going to these jurors. So they were hearing things that they were not supposed to hear.
And one of the most critical things, which the judge ruled that they should not hear, was dealing with Detective Furman. Now, obviously, they knew all of that. Now, once you discredit Detective Furman's testimony, that becomes critical because the very blood that they spoke about and all of the circumstantial evidence flows a great deal from his testimony.
Now, Judge Rappaport, you've been in the courtroom with cameras right there. You've been in cases where high publicity cases. What effect does cameras in the courtroom, what effect does the media have on a case to the judge?
Right. Well, first of all, I was both an attorney with cameras in the courtroom and I've been a judge with cameras in the courtroom. It's like anything else. I think that a judge, if he's being responsible, should not be affected by the cameras in the courtroom. Now, I may be saying some are and some are not. Obviously, Ito was. I was, to one respect, and we've discussed this before, I became aware by watching myself on camera that it was wrong for me to suck on hard candy because you could see that on camera. And I think that's the only effect during the Crown Heights trial that I was affected with. Now, I think, the cameras in general, it would be so simple. I held this debate up at Fordham Law School with Judge Keenan, who's a federal judge, and Judge Connerboy. They both are against cameras, period, in the courtroom, which is a federal...
By the way, one of the effects, I think, of the Simpson case was that the federal courts have now pretty much closed the door on cameras in civil trials. They were meeting on this issue while the Simpson case...
Defense bar. Are you in favor of cameras?
Yes, I am.
You are?
I don't think
it's
that...
not prejudicial to your clients?
If it's done properly... remember now, the cameras in the courtroom is only an experiment. It has never been officially...
In New York State.
In New York State. It has never been officially condoned by the legislature. It's still an experimental state.
Judge, in all cases?
Cameras in all cases?
Right.
They won't be in all cases. Let's analyze this. This is, for the most part, cameras in the courtroom is a money-making proposition for the people that bring the cameras in. Whether it's a news program or court TV, they have sponsors. They make money, they get viewership, and that's how they sell time. So they're only going to come in high-profile cases or cases that have an interest.
And cases involving sex, murder, things like that.
No, they will.
Those are the sensational cases.
It has to be something jazzy that they're going to come in for.
They're not going to come in on a commercial case. They're not going to come in on anything other than what sells. And what sells is the same thing that sells soap operas. Murder, robbery, sex, adultery, things like that.
What do you think of Cochran? Johnny Cochran.
Johnny Cochran, the attorney. What do you mean, what do I think of him?
Good, great job.
Great limorist. He really is. If the hat doesn't fit, you have to acquit. I mean, could you think of any better type of... If the hat doesn't fit, then you must acquit.
And that's what one of the jurors said when they interviewed one of the jurors.
Right, right. He worked very hard. He's a polished lawyer. He had a difficult task. You know why? You know the expression, too many cooks ruin the broth? I think it's impossible. I would never want to be in that situation.
I think there was over a dozen defense attorneys.
Who wants all these lawyers? Everybody's going to have a different approach. Should we do this? Should we do that? I mean, they argued over everything. It's terrible. I wouldn't want
Marsha Clark.
I think she did an adequate job, except for a few things. First, I don't know why during Cochran's summation she didn't jump up and scream when he argued his jury nullification argument. That send a message, go out there, ladies and gentlemen of the jury, and send a message. I would have been screaming. I used to be a prosecutor. I would never have stood for that. But she let it go. I'm not sure why.
Which is against the law, by the way, of California and New York. We don't have jury nullification. Which means, I don't know if your audience understands even what that means. In other words, if I charge someone, if you find this fact and this fact and this fact, and they satisfy the elements, and if you decided that beyond a reasonable doubt, you should convict. Jury nullification is where you tell the jury, even if you find that, in fairness, forget about it. Find them not guilty. Don't believe the law.
She bungled it when this business of trying on the glove. I mean, that to me was ridiculous.
And one of the jurors pointed that also. So they did the experiment. The glove didn't fit. You must
acquit.
Judge, you run a very tight courtroom. That's your reputation. If you were trying the case, how tight would you have run it?
Well, the first thing is, it's a question, who runs the courtroom, the lawyers or the judge? The lawyers represent clients and they perform their duties within the courtroom. But the cop of the courtroom is the judge. He's in charge. Now, you have to do this you have to do it even-handed, you have to do it fair and under the law. But there must be one authority figure in that courtroom, and that's the judge. And the bar and the people that come into the court have to have a sense that there's a place that they could come in which deals in fairness, that's impartial, and that has to be the court. In order to do that, you have to let people know what your guidelines are and stick to it. And if that's running a tough ship, then I run a tough ship.
Judge Rappaport, the New York Post, the reporter Jack Neufeld reported that you were listed as one of the 10 worst judges in New York City.
I read that.
We invited the New York Post down. They declined to come. How do you respond?
Well, I wish they would. I mean, Jack Neufeld and I can't remember his first name, Newman, who wrote that story, have refused to publicly appear anywhere with me or to comment on that story that they wrote. There's a lot of inaccuracies in the story. You know, first of all, what happens is they pick 10 people. It's like the 10 worst dressed people.
Or the 10 worst journalists.
Or the 10 worst chefs, or the 10 worst, I don't know what the criteria is. I have to assume that Mr. Neufeld interviewed or got interview or information on all the judges in New York State, of which there are approximately 1,000 judges. Now, we know he didn't do that. What he did was, he spoke to people, he got things that displeased him. He was displeased with the result of Crown Heights and the fact that Limerick Nelson was acquitted. And he, therefore, I became a nominee on his list of the 10 worst judges because I presided at that trial. He blames me, or Mr. Newman more specifically, because he wrote the story, for the acquittal. I don't think we have time, nor should we debate whose fault the acquittal is, but it certainly was not mine because there was a report. See, it's very interesting. Most cases are tried, and that's the end of it. This case, for some reason, the governor appointed a special commission to look into the case. And one of the issues that Mr. Neufeld raises in his article is that I improperly charged acting in concert. And I assure you that, number one, Mr. Newman, who wrote the article, or Mr. Neufeld, who was associated, do not have the slightest idea what the proper charge of acting in concert is. Number two, I guarantee you they never read the charge that was given to this jury because it was sealed upon acquittal, and they weren't in the courtroom when it was rendered. I dare say they didn't see 1 second of the trial.
See, this is a reason why the media has such a responsibility, and sometimes they unfairly attack a judge. And of course, Judge Rappaport, as most judges, under the rules of ethics, is not allowed to respond. But the media has an obligation to report fairly and accurately. And this was a real horror story, because Judge Rappaport happens to be one of the best judges in the county. He probably knows more about criminal and civil law together than most judges do in the entire city, perhaps the state. And yet, the media can ruin a judge's reputation, a lawyer's reputation, by not responsibly reporting things accurately. And I dare say that any judge could be ruined as far as reputation if the media set out to do that. If a judge is in chambers, in his chambers or her chambers, and the media reports the judge came out late, but they don't report that the judge is in chambers working on a motion or working on judicial business, that's unfair reporting. If they report that a judge gives probation, and they say that's a horrible sentence, but they don't report the mitigating factors that went into that, they're leaving out certain things.
Barry,
in the story.
answer me this. In the Yankel Rosenbaum matter, at least a half a dozen, I was told, at least a half a dozen police officers who were at the scene testified as to their own eyewitnesses of what they saw regarding the bloody knife, regarding it being in the possession of the defendant.
Right.
I mean, what was the jury thinking? What could they possibly have been thinking after these, one police officer after another took the stand and testified such as to eyewitnessing the defendant at the scene in such a circumstance?
Well, I wasn't there. I can only speculate that the jury chose not to believe certain police testimony.
It's a credibility issue. Let me tell you something.
Which is
We charge in every case credibility. We tell the jury that one of their functions, and you know that, is to decide whether or not you believe, based upon the quality, based upon the opportunity that the witness had, based upon the inconsistencies either between other witnesses or other things, and determining credibility. Now, something happened at that trial that caused this jury, whether they're right or wrong, but caused them to question the credibility of the police officers involved.
They must have thought they were either mistaken, misguided.
No,
They
no.
didn't see what
They
thought. What?
there was
didn't
a
believe the officers.
tremendous
They didn't.
difference between a transit police officer's testimony and a city police officer's testimony dealing with the murder weapon.
More right after this break. You're watching Lawline. I'm Alan Schnorman, your host. Stay with us.
The air dances with the waters, which brings the rain that feeds the land, that is home to the animals. All life dances together.
In a world so connected, choosing one environmental cause can be hard. EarthShare is 40 environmental charities working together. You and your company can help by calling 1-800-MY-SHARE.
All life lives, or doesn't, together.
Excuse me, do you wear your safety belt?
Why, no, I don't wear my safety belt.
Thank you.
You could learn a lot from a dummy. Buckle your safety belt.
This warehouse is 5 stories tall, and it contains 45 million pounds of donated food. That's enough food to feed every hungry person in America for one day. Hunger is eating America alive. But if you can make a call, you can make a difference. Call Second Harvest, America's food bank network. Together, we're hunger's hope.
Hello, you're watching Lawline. I'm Alan Schnorman, your host. Today we're talking about the responsibility of the media to accurately portray the judicial system. Our guests are Judge Edward Rappaport, Supreme Court Justice, Kings County, and Barry Kamens, past president of the Brooklyn Bar Association. Judge, O.J. Simpson case again. What effect do you think the media had on the ultimate verdict?
Well, probably it depends. If they were receiving information, the jurors, from people that were visiting them, and these people were learning about the case through the media, then it had a tremendous impact, because things that the court wanted the jury not to know about, that were questions of law, they were finding out about because their relatives were watching it on television and then telling them. That's a tremendous impact.
How does that differ from 99% of the trials where the jurors are not sequestrated from the day one?
Simply, I mean, television's in the
First
court.
of all,
Yes.
Well,
Go
first
ahead,
of all, there's
Barry.
never been the type of publicity that there has been in the Simpson cases. As everyone has said, it's the trial of the century. Your run-of-the-mill garden variety case has no publicity, and if it does, the jurors can easily avoid reading one article in a newspaper. But this was front page headlines, 6 o'clock news, 11 o'clock news. It was almost impossible for this not to get back to the jury.
Let's assume that Judge Ito made numerous mistakes during the trial, and all those mistakes led to the acquittal of O.J. Simpson. Had it gone the other way, had he made numerous mistakes, and he would have been convicted, certainly he would have an appeal. Is that correct?
That's
And the
correct.
prosecution doesn't have an appeal.
That's correct.
Well, that's a basic concept of our country, double jeopardy. Let's not even question that. I think it's a wonderful concept.
Let's
People
talk
should
about
be
the
protected.
rights of the accused vis-a-vis the
That's
media.
the problem. Now, you have to understand something. The public generally, and maybe correctly, are suspicious of the criminal justice system, courts, judges, police officers. They think that there are things that happen they don't quite understand. They don't understand the law. So that bringing the cameras and the news media into the courtroom in high-profile cases where the public is concerned doesn't have to rise up to O.J. Simpson. There are many other instances of cases where the public is concerned, I think, is important. I think that we shouldn't make a rule, because then the public's going to say, particularly those that feel aggrieved for one reason or another, sure, they don't want the cameras in there because they want to continue doing what we always knew they were doing, tricky things. So there is a need to let the public be someone that could know what's going on.
The right for the public to know. It's
Now,
very, very
now
important.
maybe if we could create a courtroom that seats 1 million people, then they could be spectators.
Right? TV does that.
That's what TV does. So therefore, if you conceptually think that they're going to be spectators, that it's the judge's duty to run the courtroom in such a way that things do not get before the spectators, which is the vast audience that's watching the television sets, that they shouldn't see in the first place, and that the jury shouldn't know. So that if you could then keep away from the television cameras those things that you do not want the jury to know, because there are questions of law and things of that matter, then we don't have the same problem.
See, the critics will also say, while Simpson was gavel to gavel, you could watch the entire trial. Most trials where there's coverage by the TV, they take out snippets, put it on the 6 o'clock news, and the public doesn't really see what happened at that trial. So although the media is there, the public's right to know is not really being
Sound
enforced.
bites. They can confuse
However,
you with sound bites.
In addition, in the Simpson matter, if I recall, there was so much pretrial matters that even before the jury was even selected, you saw part of the testimony.
I will not permit, and first of all, if there's an objection in New York State by one of the persons involved to pretrial matters like a hearing
Right.
to determine the admissibility of evidence. But I, as a judge, won't permit the television cameras at that point of the trial, because that's before there is a jury. Of course, except in Simpson, they did it another way. But normally in New York, all your pretrial matters on search and seizure, confessions, identification, and so forth are done before you pick a jury. Therefore, in order to protect the integrity of the trial, so that you could pick a jury that's not aware of what the rulings were, the cameras are not in for
Judge,
that.
let me ask you this. In high-profile cases, how is the judge selected?
Well, all cases, the judge is selected in New York State by lot.
Including high-profile cases?
Well, with exceptions. Let me explain so you can understand it. In Brooklyn, we have approximately 46 judges that sit on the criminal side. Brooklyn has divided the borough into 5 areas. They color code them, the red zone, the green zone, what have you. And they try to take a geographical area that is somewhat contiguous to each other, but have high-profile precincts, police areas, and low-profile, and mixed both ethnically, racially, and so forth. And that creates a zone. They got 5 of them. The whole borough is broken up that way, and it's for trial purposes. But they also realize that there are certain types of cases, high-profile murder cases, mob killings, certain types of robberies, a lot of rape, anything that has to be handled by special type of assistance because of knowledge and skill. So they created in Brooklyn initially 6 non-aligned parts, meaning they have nothing to do with these geographical locations. And by the type of cases, so that when the Crown Heights case, there was an indictment, that case could have only gone to one of 6 judges.
I see.
Because it was not a case that was going to be handled in the zone areas.
That's one county. I mean, each county has its own way administratively of picking the judge who will handle that particular case. In New York County, I'm not that familiar with the way it's chosen, but it seems that the certain judges always get those types of cases. Maybe they have a way of selecting, again, as Judge Rappaport said, a group of 6 judges or 7 judges, but it seems that certain judges get the high-profile cases.
Now, in Brooklyn, the 6 judges that were picked by experience, their prior experience on the bench and their experience on the bench, that they were able to handle more complex or high-profile cases. Which doesn't mean that other of the 46 judges couldn't, but these were the 6 judges that were picked. So that when the Crown Heights case or the Limerick-Nelson case came out, the picking of, which was also by lot, was 1 out of the 6 judges.
Barry, question. Going back to O.J. Simpson, Chris Darden, what did you think of his performance?
I thought that he improved greatly as the trial went on. I thought that he started off very clinically, and I think his summation, the part that he gave, was a very emotional summation, and I thought it really reached the jurors. Obviously, it didn't reach them far enough, but I think that of course, I don't think that he controlled himself enough in his exchanges with Cochran. I think he got caught up in that. I think Cochran baited him. I think he was tempted, and he went too far.
Bailey.
F. Lee Bailey was, well, if you think about it, F. Lee Bailey was the one who brought out the N-word, which turned this whole trial around. So from that point of view, people think he turned the case around. I wasn't that enamored of Bailey. But
you were a lawyer before you were judge. What did you think about this thing between Shapiro, F. Lee Bailey, and Cochran?
Well, as I said before, whenever you take high-profile lawyers and you put them together to represent the same person, you're going to have that.
Ego. It's called ego.
It's not only ego. Every case has an approach. Now, if I try a case and I think the case should be, have a trial strategy. And if I think a case should be tried a certain way, and I'm representing a client, I don't have anybody else convincing me, I'll try it that way. You bring in a second lawyer, he may disagree with that approach. It doesn't mean either one of us are right. But now you have a conflict. You got one client. Now you got a client here. O.J. Simpson doesn't have the slightest idea how that case should be tried. In my view, I could be wrong. I never spoke with him. So now you add to it a third lawyer, and then you bring a fourth lawyer in and a fifth lawyer, and then you bring in a professor from Harvard who's an expert on appellant. But by the time you got done, you're going to have every possible approach there is to a case. How can you not have conflict?
Race card issue.
You mean dealing from under the deck and all of that?
What's your opinion on that? Well, on the summation, where he brought in Hitler and those items.
Well, I don't know about Hitler. I think that was outrageous. I mean, no one could accept that type, and I think that there should have been an objection, and the judge should have stopped that. But as far as the argument, that came out in the trial that Furman was capable and had done it in the past, that he would frame someone because he didn't like A, blacks, and two, he certainly didn't like interracial coupling. Now, I think that if you're looking to attack someone's credibility, and if he is the linchpin of the whole case, how can you not try the case that way?
But the problem was he extended that and he said to the jurors, look, blacks are not getting a fair deal in this country. Blacks are being intimidated by police. Go out, send a message, you know, and this is the problem that was in Cochran's summation. And that's why there should have been an objection and why the judge should have sustained it.
Supreme Court Justice, New York County, former Supreme Court Justice, was quoted as saying that a black man cannot get a fair trial in the city of New York. What's your opinion on that?
Not true.
It's ridiculous.
Matter of fact, if you look at the panel, I mean, I just don't think that's true. And I really think that you have to have more respect for the citizens of this city. I think that you have people of all races that come and really want to do a good job as a juror. And they, you know, it's amazing. If you take 1,000 cases and see 1,000 verdicts, and you analyze the facts of the case beforehand, then look at their verdicts, I bet you that 90% of them are right on target, that these jurors bring in what an individual judge would, or you as a lawyer if you looked at it yourself.
In the moment we have left, what do you want to tell jurors, potential jurors out there about service in your courtroom?
Right. If you want to live in a nation such as ours, where we have this precious right of trial by jury, you have to not look for someone to help you get you out of jury duty. It's important that we have people from all walks of life, everybody of the community, making our system work. That's what I would say.
By January 1st, the law has been changed. There'll be more and more jurors, lawyers, doctors, even judges. Judge Rappaport may wind up on a jury.
I could hardly wait.
And I think it's a great law because it eliminates the exemptions and disqualification.
And this was brought about by Judge Judith Kaye.
Judge Edward Rappaport, Supreme Court, Kings County, thank you for appearing on Law Line. Barry Kamens, past president of the Brooklyn Bar Association.
Thank you, Alan. Thank
you for coming down to Law Line. And as always, this is Alan Schnorman. Thank you for watching Law Line.
You have been watching Lawline with your host, New York trial attorney Alan Schnorman. Mr. Schnorman will be back with you next week at the same time. If you have any questions about this week's program, please write to Lawline, 63 Wall Street, New York, New York, 10005, or call area code 212-432-9111.